She opened her door to keep her mother off the street. 2 months later, a judge had to decide whether that single act of compassion had cost her the right to live in her own home. The judge's next words would change 3 lives forever. Here's the full story. To understand how we got to that courtroom, you need to understand who Sarah is. A woman in her late 20s, living in Portland, Oregon, sharing a rented apartment with her younger sister. She had spent years quietly constructing something stable, her own lease, her own routine, a life she had built carefully after a difficult upbringing. She was proud of it, and she had every reason to be. Her mother, we'll call her Linda, had spent years making decisions that gradually pushed her daughters away. The specifics are personal, but the pattern was consistent. Choices that created chaos, consequences that fell on everyone else. Then, a few months before this story begins, Linda packed up and moved across the country to live with a man she had met on TikTok. That relationship lasted approximately 8 weeks. When that relationship collapsed, Linda was stranded, out of state. No savings, no backup plan, she called Sarah, and Sarah, despite everything, said yes. She would take her in temporarily. No written agreement, no end date, no terms, just a daughter doing what she believed was the right thing. That single act of mercy would become the center of a legal dispute none of them saw coming. From Sarah's perspective, the understanding was obvious. This was temporary emergency shelter, not a permanent arrangement. Her home, her lease, her rules. What she had not anticipated was how quickly the situation would erode her mental health. She was falling back into coping habits she had worked hard to leave behind. She was dreading coming home every day. And her mother, meanwhile, was showing no urgency to leave. Linda had been turning down job opportunities for 2 months. Sarah tried gently, then directly. The sooner you have income, the sooner you can get your own place. Every time, Linda shut it down. Don't tell me what to do. Until one night, Sarah reached her limit. She told her mother plainly that this was her home and she did not want her there long term. That was the conversation that lit the fuse. What would you have done at that moment? Now let's give Linda a fair hearing, because a court would, and so should we. Linda is a woman in genuinely desperate circumstances. Effectively homeless, estranged from her family, rebuilding after a failed relationship that left her with nothing. When you are that exposed, you hold onto whatever stability you have. Tightly. From Linda's view, she had been invited in, she had been staying there for 2 months, and she believed she had rights that her daughter could not simply override. And here is where Linda's argument becomes legally interesting. She told Sarah directly, "You cannot kick me out. I have been receiving mail at this address. I am a resident now." She threatened to sue if Sarah tried to remove her. Many people would dismiss that as desperation talking, but in the state of Oregon, that argument carries real legal weight, and that is where this story gets complicated. There is also a third person in this equation, Emma, Sarah's younger sister and the other name on the lease. Emma had a softer, more forgiving relationship with Linda. When Sarah moved toward forcing their mother out, Emma drew a hard line. She would stop paying her share of rent entirely if Linda was evicted. Consider what that actually means. A co-tenant threatening to destroy the household finances and potentially get all 3 of them evicted to protect someone who was never on the lease to begin with. So what does Oregon law actually say? Oregon is one of the most tenant-protective states in the country. And here is the critical fact that many leaseholders do not know going in. Oregon does not require a written lease to establish a landlord-tenant relationship. Under Oregon Revised Statutes Chapter 90, if someone occupies a residence with the leaseholder's permission and that occupancy continues over time, they may be considered a month-to-month tenant, whether or not a single word was ever put on paper. Courts look at several factors to determine whether informal tenancy has been established: duration of stay, receipt of mail at the address, any contribution to household expenses, and whether the primary leaseholder granted ongoing permission. Linda had been present for 2 months. Mail had been delivered in her name. Permission had been granted verbally. Under ORS 90-100, these factors together can establish what the law calls a month-to-month tenancy. And a month-to-month tenant has real, enforceable legal rights. That means Sarah could not legally say, "Get out tonight." Oregon requires formal written notice, a minimum of 30 days for month-to-month tenants in most situations, with some cities extending that window further under local ordinances. And the notice itself must meet precise procedural requirements. specific formatting, specific delivery methods, documented properly. Miss a single element, and that notice is legally defective. The clock resets. You start over from zero. When Sarah consulted a tenant rights attorney, the conversation was sobering. The attorney confirmed what Sarah had feared. Linda likely had at minimum an informal month-to-month tenancy under Oregon law. Verbal permission, 2 months of continuous occupancy, mail received, it was enough to trigger legal protections. There was a formal process Sarah had to follow. There was no shortcut. There was no exception made for good intentions. Sarah served Linda a formal 30-day written notice to vacate, delivered by hand, with a witness present, everything documented. Linda's response was immediate. She contacted Oregon Legal Aid, and Oregon's legal aid system is substantial. Linda qualified for free representation. What had begun as a kitchen argument between a mother and daughter was now a formal legal dispute with licensed attorneys on both sides. The hearing was scheduled. The clock was running. Linda's attorney filed a response challenging the eviction notice on procedural grounds. They argued the formatting failed to comply with Oregon's specific statutory requirements. And yes, there are precise formatting requirements under state law, and that Linda's informal tenancy entitled her to greater protections than had been provided. Meanwhile, Emma made good on her threat. She stopped paying rent. The household's finances began unraveling in real time. The case reached an Oregon circuit court. Sarah testified about the original intent, temporary emergency shelter, not a lease. She submitted text messages documenting Linda's refusal to take available jobs and dismissal of household rules. Her attorney argued that Linda was a gratuitous licensee, meaning someone granted permission to be present as a guest, not a tenant with ongoing statutory rights. It is a meaningful legal distinction, and it would be central to the judge's decision. Linda's attorney countered with the facts on the ground. 2 months of continuous residency. Mail delivered to the address. No formal end date established when Linda arrived. And most critically, Sarah had never charged rent. The defense argued that even without payment, the pattern of extended occupancy with ongoing permission was consistent with informal tenancy under Oregon statute. This was no longer just a family dispute. It was a question of statutory interpretation before a judge. The judge ruled, and it was a split decision, the kind that satisfies no one completely and reflects precisely how real law operates. The court found that Linda did not qualify as a formal month-to-month tenant because no rent had ever been exchanged, and Sarah's original invitation had been clearly framed as temporary emergency shelter. Linda was a gratuitous licensee, not a tenant. However, the court also found that Sarah's notice had not been served in full compliance with Oregon's procedural requirements. The notice was defective. Sarah had to start the process over entirely. The message to Sarah was unambiguous. You have the right to reclaim your home, but Oregon law does not bend for good intentions. The procedure must be followed precisely. A corrected, fully compliant 30-day notice was required. A new countdown began. Linda was ordered to vacate by a court-specified date approximately 5 weeks from the hearing. Noncompliance, the judge made explicit, would carry legal consequences. The Emma situation was addressed separately. The judge had no direct jurisdiction over Emma's private lease agreement, but Sarah's attorney laid out the exposure plainly. If Emma withheld rent, she was in breach of the lease she had signed, and Sarah had legal grounds to pursue that. The threat that had paralyzed the household for weeks dissolved the moment Emma understood the actual legal consequences she was facing. She agreed to resume paying her share. Linda was referred to Oregon's transitional housing program as part of the court's resolution. The judge's tone was measured, not punitive. Linda had real resources available to her. She had time. What she did not have under the law was the right to occupy someone else's home indefinitely because the alternatives were hard. The law, the judge observed, is not a substitute for a plan. In the weeks that followed, Linda vacated on the final day before the court deadline, reluctantly, but she went. She transitioned into a transitional housing facility while continuing her job search. The relationship between Sarah and her mother remains deeply fractured. Whether time can repair it, neither of them knows yet. But Sarah had her home back. She told her attorney something simple that has stayed with me. I just needed to know I wasn't trapped. Emma and Sarah are still living together, still co-tenants. But something shifted during this process that cannot be unseen. In a crisis, Emma's loyalty went to their mother over her co-tenant and over her own signed lease. They have had difficult conversations since the ruling. They are rebuilding, carefully and slowly. That invisible damage, to a sibling relationship, to shared trust, is the cost no court ruling can ever fully price. What this case illustrates goes far beyond one family's story. Every year, thousands of people face this exact situation, a moment of compassion that becomes a legal entanglement they never saw coming. Oregon's tenant protections are among the strongest in the nation, and they do not pause to consider your intentions. Understanding the legal landscape before you open your door is not cynical. It is the difference between a temporary arrangement and a months-long court battle in your own home. If you are facing a situation like this right now, someone in your home who will not leave, and you are not sure of your legal standing, the single most important step is accurate, state-specific information before you act. I have linked Oregon's official tenant rights guide and a plain language eviction notice checklist in the description below. What would you have done if you were Sarah the night her mother threatened to sue? Drop your answer in the comments. I read everyone, and I will see you in the next case.